Hello guys, welcome to my channel Interpreter of Law. Today we are going to start with rule 2 of order 14. Order 14 deal with framing of issues. So we are going to start with rule 2 of this. In rule 2, what it is stating, court to pronounce judgment on all issues. On the all issues will be specified para-wise, and on all issues judgment has to be pronounced. Notwithstanding, a case may be disposed of on preliminary issue. First thing is that we have to first dispose the case on preliminary issue. Preliminary issue. What are preliminary issue? Preliminary issues are those issues which are on law. Issues which are on law. Issue of law are preliminary issue. For example, res judicata, res sub judice, these all are preliminary issues. First this will be decided and then other issues will be decided. Where issues, second point what it is written, where issues both of law and of fact arise in the same suit. Law and of fact, that means mixed issue of law and fact, that refers to limitation law, and the court is of opinion that the case or any part thereof may be disposed of on an issue of law only. It may try that issue first and then other issues first. Now you have to always remember that the court will first try preliminary issue, that is issue of law first. The court will decide issue of law, then after that for the other issue the court will pronounce judgment on that. Now it is written here that it may try that issue first if that issue relates to the jurisdiction of a court. Now here they have told what are issue of law. They have given example, that is the jurisdiction of the court a bar to the suit created by law for the time being in force, and for that purpose may, if it thinks fit, postpone the settlement of the other issues until after that issue has been determined, and may deal with the suit in accordance with the decision of that suit. What it is written that rest of the issues it will postpone, and first the court will decide preliminary issues. Okay, issue has been determined and may deal with the suit accordance with decision of that issue. First preliminary issue has to be decided and then other issues have to be decided. This was all in this rule. Now you have to clearly remember that firstly the court will decide on preliminary issues, that is issue of law, then after that it will decide on other issues. Okay, now we are proceeding to rule 3 of order 14, which the heading is materials from which issues may be framed. The court may frame the issues from all or any of the following materials. Now they have told the way how issues have to be framed. How the court will frame the issues? Firstly, the court has to see order 10 and order 11 and order 12. That means the court have to look into the interrogatories, what the reply come in interrogatories, what the parties have admitted, that is what evasive denials party have made or what they have admitted. This all things it will consider, and then it will frame the issues. Allegation made on oath by the parties or by any person present on their behalf or made by the pleaders of such parties. Allegations they will see, and then they will frame issue. Allegation made in the pleadings or in answers to an interrogatories delivered in the suit, the contents of document produced by either party. This all things it will see and frame the issues. Now we will come to rule 4. Court may examine witnesses or documents before framing issues. The court will examine witnesses and documents before framing issues. The court can again call for witness or any document. Firstly, the court have called in order 10 the parties to parties. It has called in order 10 for examination of parties. Now again also it can call in order 4. Okay, there is no bar that court can't call the parties. Court can call parties before framing issues, or it can call the witnesses not later than 7 days from the framing of issues. That was held in Hiruk Lal versus Batak Lal. Okay, in Indian Evidence Act, call any witness or documents with clear mind that issues cannot be correctly framed. Examination of some persons not before the court or without the inspection of some document not produced in a suit may adjourn the frame of issues to a day not later than 7 days and may subject to any law for the time being in force, compel the attendance of any person or the production of any document by the person in whose possession or power it is by some or other process. Now come to 5, power to amend strike out issues in criminal law. Now see, you have, I think maybe you know that in criminal law there is never cancellation of charge, there is always amendment or alteration of charge. Like you can make alteration of charge from 307 section to 302 section, from attempt to murder you can alter the charge, but you can't cancel the charge completely. You have to acquit the person, acquit the accused. The court may at any time before passing a decree amend the issues or frame additional issues on such a term as it thinks, and all such amendments or additional issues as may be necessary for determining the part matters in controversy between the parties shall be so made or framed. Okay, so they are telling that court can amend and strike out issues. The court may also call at any time before passing a decree strike out any issues that appear it to be wrongly framed or introduced. Okay, so this is all in rule 5, that court can anytime strike out issues, not anytime before passing a decree. Sorry, I was wrong. Before passing a decree, anytime court can strike out issues or amend or alter issues before passing a decree. So you have to remember here, before passing a decree, okay. So now come to rule 6. Question of fact or law may by agreement be stated in form of issues. Where the parties to a suit are agreed as to the question of a fact or of a law to be decided between them, they may state the same in the form of an issue. Now here the parties are themselves framing the issues. Okay, court is acting as a referee here and parties are themselves framing the issues, and these cases are called special cases where parties themselves are framing the issues. Okay, that you have to give, like for example कोई भी फ्रेम कर रहे हैं वो issues that you have to give 50k and other person has to give 10k, so they're framing the issues themselves, and later on that issues only the court will give its decision, that can be in affirmative form or negative form. A sum of money specified in the agreement or to be ascertained by the court or in such manner as the court may direct shall be paid by one of the parties to the other of them, or that one of them be declared entitled to some right or subject some liability specified in the agreement. Now in agreement parties can make the issues and court can decide that one party has to give money to the other, or any right comes, okay, or any right comes, or any liability has a reason, so the court will tell and the parties will do accordingly. Okay, b, some property specified in the agreement and in dispute in the suit shall be delivered by one of the parties to the other of them, or as the other may direct. So here, like if the court say yeah the sale is wrong or the sale is right, then the property has to be transferred. Okay, and the parties have to agree on that. What the court will say, the parties have to agree on the decision. Okay, because they have themselves framed the issues and the court will